pleasant day to you all. My name is Tadwana Shegeso Office. My colleagues and I are law students at the University of Zimbabwe, and today we'll be presenting on commercial law reforms in Zimbabwe. Before the year 2017, there were a few laws governing the law on commercial law in Zimbabwe. From 2017 up to 2022, a few amendments and a few laws have been enacted to govern the commercial law in Zimbabwe. Some of these laws which have been made include the Data Protection Act and the Companies and Other Business Entities Act, with the Companies and Other Business Entities Act being the chief law which has made Zimbabwe an attractive business destiny. My colleague Taku will be sharing more on the background of Zimbabwe commercial law reforms.
Our commercial law is largely influenced by our historical background of the law, which is found in section 192 of our current constitution, providing that the law to be administered is that which was enforced on the effective date, which was on the Cape of Good Hope, 11 June 1891. With that being said, two main sources of law emerge from this provision, which is common law and statutory law, with statutory law being the superior law and common law arguably being the inferior law. Now, in our current law today, it explains why our courts use previous judge-made decisions by Roman jurists in order to take cases. The disclaimer, however, is that South African cases and English cases are not binding in our law, simply because they're not Zimbabwean cases, so they may be used for persuasive value in our law. Therefore, by understanding the historical background of our commercial law, we give credit to our legislature, which has over the many years tried to amend provisions, particularly between 2017 and 2022.
I am going to present about the Data Protection Act, Chapter 11.12. The enactment of the Data Protection Act, Chapter 11.12, was gazetted on the 3rd of December 2021. The Data Protection Act, or law, mandates all businesses operating in Zimbabwe and outside to adhere to the data protection and privacy principles collecting data, such as personal information of their customers and employees in relation to commercial law. This pertaining to the information collected in contract of lease, insurance, and agency. Section 3 of the Act defines data as any representation of facts, concepts, information, whether in text, audio, video, images, machines, readable code, or instructions, in a form suitable for communication, interpretation, of processing in a computer device, computer system, data electronic communication network, or related devices, and includes a computer program and traffic data. From this definition, it is clear the Act covers not only the personal information of persons held by data collectors, but also curb what would be termed irresponsible use of the internet. The passing of the Data Protection Act abreast with new technology businesses are therefore required to ensure that they implement systems which promote and protect data privacy as well as processing data fairly and securely. According to Section 4 of the Data Protection Act, it applies to matters relating to access to information, protection of privacy, and processing and storage of data wholly and partly. Protection leads to the amendments of sections 163, 166 of the Criminal Law Codification and Reform Act, Chapter 9.23, by criminalizing offenses such as unlawful acquisition of data, unlawful interference of data, and unlawful disclosure of data. Through the amendments of the Criminal Law Codification and Reform Act, Chapter 9.23, by creating crimes relating to unlawful collection, use and disclosure, leaking of data, including the unlawful interception of data by any person. The amendment to our criminal law in relation to commercial law also makes it unlawful. Transmission of data, message inciting violence or damage to property, sending threatening data message, cyberbullying, and harassing. Therefore, it is clear that the coming up of data protection made changes in commercial law in terms of the regulation.
The advantages of e-insurance have been identified as easy, quick, and convenient, thus attracting customers. For the insurer, it is argued that it reduces managerial and administrative costs, eliminating costly and time-consuming stages, and develops information structures and managerial data through the process of business automation. However, the process is accompanied with disadvantages which turn out to be detrimental to the customers. The evolution of insurance businesses by information technology affects all major stakeholders, who include the insurance companies and consumer insurance brokers and the regulator of insurance and the government. The complexities of acquiring an insurance policy and claiming it have not been addressed or erased by the digital form of acquiring insurance. Nevertheless, there are e-insurance disadvantages on both sides. It is worth to note as a reform from 2017 to 2022, which is about to be regulated by the upcoming Bill of Insurance Act.
My name is Bongiko Smafa. I will be taking from where my colleagues have left on the development that have been happening in Zimbabwe from 2017 to 2022. I will be focusing on the Zimbabwe Development Agents Act. This is in short called ZIDA. There was a massive development in Zimbabwe investment laws. By the enactment of ZIDA, which regulate investment laws, for years they have been caused to simplify the process of investing in Zimbabwe and to cut the red tape, which counted for the stillbirth of many proposed investment projects in Zimbabwe, and in some cases saw investment projects being suspended or even being terminated. The genesis of the problem in the investment law architecture were the evidently of the policy nature, and the government has in recent times promised to bring harmony to this critical economic era. On the 16th of February 2020, the Zimbabwe Investment Development Agent Act, year after ZIDA or the Act, was signed into law and collapsed several standalone institutions into one entity known as ZIDA. The Act is designed to harmonize all domestic laws which bearing on investment, which will promote, protect, facilitate investment into Zimbabwe. Its promulgation has been described, amongst other things, as signifying a new chapter in how the country has advanced in the ease of doing business, a cause of a celebration. It aimed to provide for the promotion, entry, protection, and facilitation of investment, to provide for the establishment of Zimbabwe Investment and Development Agents, to provide for the One-Stop Investment Service Center, to repeal the Zimbabwean Investment Authority Act, Chapter 1430, the Special Economic Zones Act, Chapter 1434, and the Joint Venture Act, Chapter 22.22, to provide for matters incidental or to connect to the foregoing provision of the repealed entities, which used to deal with investment separately, was incorporated under one roof in ZIDA. And this lessened the burden on investors, and it makes easier for them to register their business and start operating. It is meant to attract foreign direct investment, the benefits of which are innumerable. Some of the benefits being chased by the new law include stimulation of economy, simulation of international trade, development of human capital, resource transfer, reduced between revenues and costs, increased productivity, increase in revenue tax incentives. Enactment of the Act. There were three main pieces of legislation which govern inward bound investment in Zimbabwe, depending with the nature of prospective investment proposed. There were the Zimbabwe Investment Authority Act, the Special Economic Zones Act, the Joint Venture Act. The Joint Venture Act essentially dealt with private-public partnership, also known as PPPs, between the contracting authorities and the private companies which undertake the financing and construction of the infrastructure project, with a few to hand it over to the contracting authority after completion. The contracting authority would then reimburse the private company to total investment of the project at an agreed rate. To mention a few commercial law pertaining international investment change, investor protection provision, it must be noted that the Act brought in comprehensive investor protection provision of importance to note in part 3 of the Act, which provide investor guarantee on non-discrimination and fair treatment of all. In terms of the new investor, who will operate freely without being compelled to cede any investment to another person, either directly or indirectly.
I'm Leon Mzakwe, and I'll be presenting on Insolvency Act, Chapter 6.11, considering the changes that has happened from 2017 up to 2022. Before 2017, there was an old Insolvency Act in Zimbabwe. The old Act was unconcerned with the rights of employees on insolvency of the employer. But however, the new Insolvency Act points in a different direction. It guarantees limited rights of workers in their capacity as creditors and employees. There is a convergence of insolvency law and labor law.
Pleasant day to you, ladies and gentlemen. My name is Nikiwe, and I'm going to speak to changes that related to the company law in Zimbabwe during the area of study, that is from 2017 to 2022. There was a new act that was introduced, which is titled the Companies and Other Businesses Entities Act, Chapter 24.31 of 2020, which repeals the old act which was enacted on the 1st of April 1952. This was meant to amend and consolidate laws that were in force in Zimbabwe that related to the constitution, incorporation, registration, management, and winding up of companies and other associations. The previous act lagged behind constitutional, technological, economical, and other developments that took place in Zimbabwe over the years. Consequently, the legislation lacked these progressive mechanisms such as corporate governance. For instance, the issues relating to shareholders and other officials like the directors, there were no adequate regulations that effectively protected the interests of the company and those connected to the company one way or the other. So consequently, these shortcomings and limitations that the new act are the ones that motivated the coming in of the new act. In summary, they constitute the constitutionality, technology, economy, issues of directorship, adequate regulation, transparency, and accountability. Now I'm going to talk about the changes that are found within the new act that was enacted. There were issues relating to registration and incorporation of companies. One of the key issues that the new act seeks to address relates to the registration of companies. This part is governed by the following sections, that is section 6 to section 19, section 75 to section 85. The new Companies Act came in to curb shortcomings of the manual registration process by the introduction of the electronic registry provided for in sections 279 to 291. The provision states the following. They state the requirements of registration, user agreements, agreement systems, registered users, digital signatures, documentation, and safekeeping. These efforts to computerize the company's registry were done under the e-government initiative, which was aimed at achieving quicker, simpler, and transparent turnouts in the registration processes. The new act has provided the legislative framework which is aimed primarily at improving the ease of doing business in Zimbabwe. There was a survey that was done in 2012 by the World Bank Doing Business Initiative, which concluded that prospective business persons in Zimbabwe could wait for about 152 days before all requirements for starting a business can be finalized. The 152 days did not account for all the registration processes that included the compilation and lodging of documentations. Therefore, a simpler standardized documents that highlight critical information such as the memoranda, articles of association can be adopted were adopted for initial registration processes, with details being presented at a later stage when the business is in operation. There were also changes that related to financial and reporting structures, which are found within the new Act, the New Companies Act. The new Act gives a comprehensive, advanced, and accounting auditing structures. This is provided for in sections 182 to sections 194. Further, financial reporting structures under the old Act fell short of details that compelled comprehensive reporting, and they left room for fraudulent activities. There were also changes that were enacted in regarding accounting and auditing. This is covered in terms of section 140 to 155 of the old Act, and sections 271 to 277 of the new Act. It should be noted with concern that the old Act had been criticized for not covering the strict compliance of accounting and auditing of private companies. However, the new Act gives strict compliance provisions to financial accounting by private companies. Thank you.
Okay, so in addition to what my colleague has just presented on, I'll be adding in line with wages and acquisitions. So the new Act introduces a new form of statutory measure which is designed to ease the implementation of business combinations. Section 228 of the new Act provides that two or more public companies or any combination of companies consisting of at least one public company and at least one private company may undertake a merger. A merger is defined in section 226 of the new Act as a transaction resulting in one or more existing companies joined into another existing company, or two or more companies consolidating into a new company. Under the new Act, companies proposing to combine or merge must enter into a written agreement setting out the terms and means of effecting the merger. This includes that the manner in which the shares of each merging company are to be dealt with. The statutory merger regime also prescribes extensive disclosure requirements as well. For instance, the merging companies must publish notice of the proposed merger in the Government Gazette and in a daily newspaper circulating in the district in which the registered office of the company is situated. It must be noted that the new Act works complementary to the existing competition law, which does not in any way dispense with the need for compliance with its provisions. Moving on to the effects of the new Act, it improves corporate governance practice by defining in greater detail the corporate responsibilities of directors and boards of companies in terms of global best practice. Secondly, it promotes disclosure of company directors, remuneration, and expose shareholders that hide behind investment vehicles.
My name is Portia, and I'm going to be presenting on the Consumer Protection Act with regards to our question, which speaks on the commercial reforms that were made in the year 2017 up until 2022. So the Consumer Protection Act, which is Chapter 14, it made a lot of changes on the protection of consumers before the passing of the Consumer Act, which is Chapter 14, which came into force in Zimbabwe in December 2019. Its main aim was to seek to promote a fair, accessible, and sustainable marketplace for products and services, and it was also made to improve the relationships between consumers and businesses in Zimbabwe. And it did not have any dedicated Zimbabwe did not have any dedicated consumer protection legislation. In short, the Consumer Protection Act, it prohibits suppliers and marketers from using any physical force, using coercion, using undue influence, duress, harassment, or unfair tactics against consumers in marketing. Service providers must not take advantage of consumers who are unable to protect their own interests due to mental or physical disability, illiteracy, ignorance, or a general inability to understand the terms. The Act also prohibits service providers from displaying any sign that purports to disclaim any liability or deny any right that a consumer has under the Act or any other law. This includes unfair contractual clauses such as no refunds, no returns, no exchanges. Suppliers are also prohibited from making false or misleading representations in marketing goods and services. This encompasses the sale of land and any other immovable property. To analyze more on the Act, it answers the following. When does the Consumer Protection Act apply? Who is the consumer? What are the consumer rights? The Consumer Protection Commission penalties against any consumer practices. The Consumer Protection Act, which is CPA, and the accountants. To start with, when does it apply? It applies to every transaction occurring within promotion in Zimbabwe, or supply of any goods and services occurring in Zimbabwe, and goods or services that are supplied in Zimbabwe. The new Act does not apply to the following goods and services supplied to the state: employment contracts, sale of immovable property. Furthermore, under the Consumer Protection Act, it introduced the advert on the e-commerce advert. Technological advancement has paved way for a new global phenomenon called the e-commerce or the electronic commerce. The convergence of internet technology, which is ICT, has been increasing, and consumers increasingly transacting electronically. In particular, Part 4 of the CPA deals with under electronic transactions. This section, consumers must have full information to the products that are being sold or the products that are being hired online, and the supply services must protect the personal information of the goods online. The Act further introduces cooling off periods for goods and consumers' electronic transactions, which give consumers the ability to change their mind on transacting with suppliers without any penalties that are involved. The coming of the Consumer Protection Act also made changes on accountants. Accountants consume and supply goods and services every day in their personal capacity or as part of their organizations and communities. Accountants can now use the class action route to sue its suppliers, including as lawyers, for unfair, unreasonable, and bad quality products and services. Clients are now also armed with additional protection that is provided for in the CPA against unfair, bad value, bad quality decisions that are given by everyone in this room are also included. The industry also now has a statutory obligation to inform its clients about any unnatural risks associated with the products and services it provides. By virtue of the fact that they supply goods and services, it is assumed that we warrant by law that whatever we supply is of good quality. Accountants now have a statutory responsibility to be fair, to be transparent, to be honest, and to be efficient in all their dealings or face criminal or financial sanction. I will allow my learning colleague to further explain on the reformations that were made with regards to commercial reforms in Zimbabwe from 2017 to 2022.
Taking over from my colleague, you can also find out that the new Consumer Protection Act Act introduced the penalties against anti-consumer practices. Many consumers have been complaining to the government or the CCZ of being unfairly treated by businesses. The anti-new CPA under Section 78 to 81 provides for penalties against consumer practices. As such, the provisions of these sections make it an offence for any business or person not to comply with the CPC or courts. To mention one of the sections that regulate consumer penalties, Section 78 states that the offences to relation to disclosure of confidential information. 1. It is an offence to disclose any person's confidential information obtained in carrying out any function in terms of this act, or B, as a result of initiating an investigation or participating in any proceedings in terms of this act. 2. Subsection 1 shall not apply to information disclosed A, for the purposes of the proper administration or enforcement of this act, or B, for the purpose of the administration of justice, or C, at the request of an investigator, inspector, regulatory authority, accredited consumer protection advocates group, commission or court. 3. Any person who contravene this section shall be guilty of an offence and liable to a fine not exceeding level 14 or to imprisonment for a period not exceeding 2 years or to both such fines and such imprisonment. The Consumer Protection Act also led to the introduction of Consumer Protection Commission, CPC, which focus on the protection of the consumer. The Commission performed the following functions. The functions of the CPC are essentially to promote, enforce, and protect consumer rights in the country. The CPC also protects consumers from unreasonable, unjust, or otherwise improper trade practices, as well as deceptive, misleading, unfair, or fraudulent conduct, promotes fair business in corporations, coordinates and networks consumer activities and liaises with the consumer organization and the competent authorities and agencies locally and outside Zimbabwe to protect consumer interests, provide a consistent, accessible, and efficient system of consensual resolution of disputes and redress arising from consumer transactions. Thank you.
To round up on what my colleagues have already said, from 2017 to 2020, there have been a lot of reforms to our commercial law. In fiscal reforms, our common law, the private sector, and amend statutory provisions such as the Data Protection Act, Companies and Other Business Entities Act, and the Consumer Protection Act. The most rewarding amendment made in our commercial law was long-awaited Companies and Other Business Entities Act, which has arguably improved to ease of doing business as well as ensuring that Zimbabwe can be a more attractive investment and business destination. The previous act lagged behind in constitutional, technological, economical, and other developments that have taken place in Zimbabwe over the recent years. Thank you.